We're back. Thanks for staying with us. Planet Green Trees, episode number 193. We're about to get into the Entrapment discussion, and welcome everyone to call in and ask whatever questions we're going to have. In fact, joining us right now is attorney Daniel Groh. Dan, welcome back to the show, and how have you been? What's going on?
Oh, it's great to be back on your show, and good talking to you again. And I wish I had good news, but it seems like sometimes good news is far in between in the medical marijuana field. But, yeah, I've been doing great, but I had a real disappointing opinion come down. Well, actually a series of disappointing opinions, first from the Michigan Court of Appeals, and then later I filed an application for leave to appeal to the Michigan Supreme Court. And both courts failed to review a trial court opinion over here in Berrien County, where basically the judge said it's okay for an undercover cop to trick a caregiver into selling marijuana with a fake medical card. And
let me ask you this, because this is one of the concerns. I know that, and this is really one of those. Agree with me or not that there's no exact way to, interpret how the court, their reaction to it. I mean, they did not rule on any substantive issues, and these were pretrial rulings, legal issues by the trial judge that were appealed by way of interlocutory appeal. Is that right?
That's exactly correct. What happened is before trial, and Mr. Miller still hasn't had his trial. That's scheduled in the future. We brought, pursuant to the Act, a motion to dismiss under Section 4 and a motion under Section 8 to the best we could, as well as the entrapment motion argument, as well as some estoppel and due process arguments. And the basic idea is that matters of entrapment need to be decided by the judge before trial, as would a Section 8 issue. And, of course, if you're immune under Section 4, your case should be dismissed at the earliest opportunity. So those motions were all heard together, really. And we have a different trial court judge now. There's been some changes over here in Berrien County. So we'll be going back to a different judge. But that's absolutely correct. These were all pretrial motions, and the two appellate decisions, Court of Appeals and Supreme Court, didn't touch the merits. They just said, basically we're not going to answer those questions today.
Now that has some meaning, and I want to kind of explain to the listeners who don't know the nuances of this, what it means sometimes. For example, we've heard of, we were just talking earlier about when the United States Supreme Court denies a writ of certiorari on some federal court of appeals issue, they're essentially saying that they agree with the ruling, not agree with it, but it's not tragic enough that they need to hear it. They're going to let it lie as it does. In this particular case, that was not really the evaluation of the Court of Appeals' determination as to whether they're going to take the case. The real test of the interlocutory appeal, which is before trial, is whether or not your or the defendant's rights are immediately going to be denied in some particular way. In other words, the justification of denying taking the appeal now is that the defendant still has the right to go to trial, right? I mean, that's what now if it's the other way around, they may be more inclined to take the prosecutor's appeal because the charges have now been dismissed against them and they've lost the right to go to trial on behalf of the people. Would you agree with that?
Yeah, that's pretty fair. But the twist here was that during the pendency of this litigation, the law in Michigan has changed significantly twice. The original, back in December 2010, we had a trial court in Isabella County that said one thing. Then we had the Court of Appeals come along in August of 2000 in the McQueen opinion and switched the law. And then in February of 2013, the Michigan Supreme Court answered the question, reached basically the same outcome, but used a completely different analysis. And so we were really hopeful that because this case went up while that law was flip-flopping, we were real hopeful that one of the courts, either the Court of Appeals or the Supreme Court, would tell the trial court judge, yes, the law has changed. The way the original trial court judge issued her opinion, That law is no good anymore. And here's how you do it when we send it back to you. They didn't take, Judge Kavanaugh would have granted leave, but the other justices didn't see it that way. So I was really hopeful that when it got sent back to trial court, they would give some instructions, at least recognize that the law had significantly changed from back when my original motion was denied back in August of 2012.
Well, it doesn't mean that at some point in time, this decision to not take the interlocutory appeal at this point doesn't mean that the entrapment ruling, the Section 8 ruling, and or the Section 4 ruling would not be heard by an appellate court or even the Supreme Court. It just means for right now. And I guess
that's absolutely correct.
Okay. And then the next question, which I think is even more, I'm afraid what the answer is, because by ruling, I don't know, maybe this hasn't been ferreted out yet because it's new, but by ruling this way, by denying the Section 8 defense, which, was vitiated by the police activity, and I'm sure you argued that, what impact does that have? I mean, if the underlying charges of this case involve a police officer faking as a patient and transferring marijuana, that's still going to go before the jury. I mean, you can't have the witnesses lie. You can't eliminate the actual facts. Your client can say the reason I transferred the marijuana is because they told me they were a patient. I believed them, right? All those things can still. Or are we in the world of the absurd of Barb Agro that people are going to have to tell a different story to fit the ruling, so to speak?
Well, that is the million-dollar question, and we will know a lot more. Now that we're back to trial court, the trial court has set this thing for hearing on April 25, 2014, this year. It's 1:30 afternoon in Berrien County in St. Joe, Michigan. And, people in general don't come to these hearings, but this might be a motion hearing where if this judge is going to rule that he's going to ignore pretty much common sense and say that we're going to have one of these imaginary trials where no one can say certain magic words, I think the public needs to hear about it. Because the police reached out to my client. It wasn't his idea to sell to this guy. He said, no, I'm not going to sell to you unless you can get a card. He went out and got a card and showed him the card with the matching ID, and he said that he was hurting. He said that he couldn't get marijuana for his medical condition. He couldn't grow it himself. Every sob story in the world to get my client, in perfectly good faith, transfer medical marijuana to the guy. So, I mean, it absolutely would not have happened but for super sneaky, dirty tactics. And that's the whole idea of entrapment. There has to be some limit on police behavior. And it's an objective standard that's applied. And, I mean, there's other judges that have found this argument that I've made convincing. I know Judge McMillan, in one of your cases, found the argument convincing. And I am, in response to their motion in limine, to basically gag everyone from saying anything that the jury would need to know to understand what really happened. I'm feeling today that I'm going to reassert all the arguments that I did again, but just in light of the new McQueen decision, because I think that even the due process arguments are even more plain now. The old judge just said all sales of medical marijuana are illegal. That's not the law anymore. That was her only analysis. So that obviously has to be re-explored, and all those factors that I've mentioned and you mentioned, I can't imagine the jury's. If the judge prevents us from talking about those things, the jury's going to be like, what? It's just not going to make any sense. So I've got a lot of problems with this whole thing.
Well, and I don't know if I question this, especially in light of the Hartwick Tuttle opinions, which I know I saw your other, reporting on that, how you were subject to a prong one of Section 8 pre-existing relationship before the certification, some insanity that they're pulling out of the Lara memo that no patient would ever have knowledge of, like it's a secret sent to doctor. Anyways, but I mean, because like today, was it today? It was today. I had a stay granted pending Hartwick an appeal on a Section 8 because it's bad. I mean, we know it's bad, and but is the alternative argument. I just don't know if this has come up by in your court seems to be the other plethora of litigation that's terrible, but the additional reading of the bracketed 12 jury instruction 12.1 involving the controlled substance. In other words, Hartwick and Tuttle use the word prescription 7 times each. 7 times these are prescription. It's not a prescription, but they're going to use the concept and perception of this being a prescription and judge the physicians as if they're prescribing a medication and expecting them to know and be understood of how much, like how much marijuana. There's no way that it's not a measurement that they would be familiar with or even be expected to know, maybe even illegal. But there is unequivocally an authorization that has taken place of your client to possess the marijuana. And you've already established that at the denial at the Section 8 hearing. You may not have established prima facie showing of prong 1, 2, and 3, but there was an authorization by the state that's undeniable. And I think that, that reading of that, jury instruction, you know what I'm talking about, right?
Right. And that's based on that one case. I can never pronounce the name, but Gilna, whatever it is.
Right.
Exactly.
But because that is a case of prescription drugs. That is a case that is. And you see what I'm saying? So they bring the
absolutely.
And it is made for someone who's authorized to, and even if it's a manufacturing, even if it's a delivery, it's just like any other normal instruction. There's no 3-pronged prima facie showing question of fact, blah, blah, appeal. This is like as if you're presenting a self-defense in a murder case. They're not going to deny you the right to present a self-defense. You're going to have to put a little bit of evidence, something beyond mere assertion, although they're never going to deny, an individual self-defense if they get on the stand and tell the story themselves. And you've already established, albeit maybe not a Section 8, the additional, showing of proof for that reading of that instruction, which says the prosecutor must prove this element beyond a reasonable doubt that the defendant was not authorized. And it's over. That's game over. I hate to see the, it almost like the Section 8 becomes, less powerful. It becomes, more of a pain than what would be done, crafting the jury instructions. Instead, just make the prosecutor, prove it beyond a reasonable doubt that it's not authorized, that they weren't authorized. You know what I mean? It's impossible.
Yeah. I haven't had a chance to really make a judge rule on that in one of my cases yet. I don't know about you. Have you gotten that instruction to a jury?
Say that again?
Have you gotten that particular instruction that we're talking about given to a jury by in one of your cases?
What's really strange is that, me and Neil had back-to-back jury trials, and I seemed like I did the first argument, and then Neil and I would talk, and he would have the same kind of arguments. They were factually different. He had a great doctor. I didn't have a good doctor, but every time in this case with Judge Nichols that I had argued the jury instructions, he ruled against me, and I filed. Then Hartwick came out with the changing of the retroactivity. He still wouldn't change it, and during the beginning of the trial when it commenced, so every time he'd ruled against me, especially on that 12.1, he'd ruled against me. And then on the day of the trial, I motioned again for a change, and he held it in abeyance. And then at the end of the trial, when he was reading the instructions, he changed his mind 180 degrees and gave me all the jury instructions. David Rudoy was there watching it take place, and he included that one.
Unreal.
And just to the opposite, Neil had won every pretrial motion, for the jury instructions that he wanted, and then he changed his mind entirely and ruled against Neil. It was upside down, but he did give that to us in the end, which was just strange and
Well, so we still have a lot of wrangling to go before we get to jury trial. So, yeah, but it makes my client's been waiting forever. I mean, this is a long ride for an average person.
When did this case start?
This case started way back. The sales we're talking about to the undercover officer occurred back in December of 2011.
It's insane. It's what a tragedy. And but let's talk about this. I mean, has the prosecutor? What's the prosecutor's name? Who you're probably fighting? I remember I had a couple.
You know him personally. You've dealt with him, Jeff Taylor.
That's right. I just wanted to get a. Anyways, is he motioning to preclude? Has he come with that already? Is that what you're facing now when you go back to the trial court? To preclude?
That's exactly correct. He actually filed that while there was still a pending stay in the case, so it was kind of funny. But in any case, yeah, that's one of the motions that will be decided on April 25.
And is this the same trial court judge that made these other pretrial rulings, or you said you have a new judge?
It is not. They did a judge shuffle down here in Berrien County, and the old judge was Judge Pasula, who you might have dealt with in the past, and she authored the original opinion back in August 2012 denying all my motions. And since then, we've been up in the appellate courts, and now we're back. And we have a new judge. His name is Schrock. And although I haven't gotten any great rulings out of him yet on any of the things that I've had before him, he has considered everything. He has listened to all the arguments. He has expressed an understanding of the arguments. And just so far, he just hasn't been coming down on the side of patients or caregivers. But that's not to say that given the right case, he might, do the right thing, so to speak. So I've got my fingers crossed in that regard.
What's your experience? Have you guys had, or you or any of the other comrades on that side of the state, jury trials, and what kind of reactions, if any, you're getting from the juries out there, or any feedback that?
Well, there's a real interesting phenomenon. When we get really good defenses in medical marijuana cases, the cases tend to go away pretty rapidly. The offers become too good to refuse from time to time. So I haven't gotten one to jury trial in Berrien County on a medical marijuana issue yet, notwithstanding many efforts. But I'm not aware of anyone else who's successfully gotten one in front of a jury on any kind of a medical issue. Other issues, other marijuana-related issues, and I think the average jury member out here in West Michigan is sympathetic to marijuana and has no problem with marijuana, but I think there's a hidden prejudice that if they've gotten this far and they're in court, they must have done something wrong, because there's so many ways to defend yourself from a marijuana prosecution. So I think there's a little built-in cynicism, notwithstanding kind of a neutral opinion about marijuana generally.
We talked a little bit about this, because I think, I like to believe that, you want to believe, like, of the jury pool that's going to be there, some people must have voted for medical marijuana, more so than any other type of crime. You don't have a changing law that involved, a majority of the populace voting for it that are the potential jury persons of a crime that, you're defending. But the combination of things you would think would stack some of the odds in one's favor, at least give you a better chance than every other type of, jury trial you would have. But, and I like to believe that, but there's a reality side to it too, which is, and then Neil was really talking about this a lot, that there is this skepticism amongst citizens that people might be taking advantage of it. It may be that they even are in favor of legalization. They may be against prohibition, but they're more against somebody trying to take advantage of or expand on. And they're looking for things like that. You know what I mean? Like they take on this role of seriously guarding the, the strictness of the, limitations, even though it's not an issue. They hear about it, they know about it, they bring too much knowledge that they're supposed to leave, out or whatever. And it's, people that really don't know. You get maybe a cross-section like that. It's, and, also with the physicians, I think there's been an inherent, and tell me what is it, that's been one of the issues. Talk about that a little bit in terms of your Section 8 hearings and, what's challenged most and how the courts are that you're practicing and are reacting to them.
Well, out here in West Michigan, I've been blessed with a couple of really good doctors. For example, Dr. Crocker in Kalamazoo. I would consider him a high standards medical marijuana doctor, and many of the traditional doctors have been recommending medical marijuana for their patients. But in each case, it's complicated, especially given the two opinions authored by Judge Saad, Hartwick and Tuttle. It just gives the prosecutor a million different ways to attack cases that pre-Hartwick and Tuttle would have seemed like slam-dunk cases. So the doctors that the ones that I'm blessed with, they come to court, they stand up for their patients, and it's great, and they give good testimony. And then the ones that are the treating doctors, more traditional doctors, things tend to get more complicated more quickly. So, and often you get patients. I mean, if you have a really sick patient that if you represent a caregiver and he has a patient that's truly ill, they might not want to have anything to do with what the judges are making defendants do nowadays to prove up a Section 8. It's a real burden on them. So people get cold feet. Sometimes they don't want to participate. Sometimes they want to keep their medical records private. And they're all legitimate issues. It's hard to tell these people that they're wrong for, not wanting to march into a courtroom and talk about using marijuana.
All right, get the crystal ball out for a second. Let me throw a couple pitches at you here. The Supreme Court, I think, agree or disagree. They could have done a lot more. I don't like where they started with the analysis of the Michigan medical marijuana as being an exemption, but for most of the critical issues, they've gone in a way that I think, most people predicted, that there was two sections of the act instead of one, I don't agree with the complete decision, and I think it could have been done differently, but, they've reaffirmed oneself and whatever. But still, there's a lot to be said, and maybe that's not a fair question, but looking forward to these two cases and the, what can only be described as a remaining issue as we walk into, move into our fifth or sixth year of the Michigan medical marijuana, the doctor certification, by these last two opinions, by the, amendments. This is a target. This is the focus. This is all the criticism comes from it. And, as these cases go to the Supreme Court, we're going to, ultimately hear once and for all probably on some of these issues, what is the real responsibility of the doctor? Is it like a prescription where they're going to be monitoring and be able to articulate the THC levels of, therapy versus what's too much? Or is it really just, as Conan B. Walter says, it's a recommendation, it's an exercise of a First Amendment right. Tell a patient what may be a good treatment for them. Do you got any thoughts on that in terms of where that's going to be, how that's going to be beaten out?
Well, everyone who's listening to this show, unless you're an undercover cop, has a very good understanding that cannabis is not like morphine. It's not like any pharmaceutical drug that you can go over to Walgreens and get, just because the way it works in the body is so different and the safety is so different. The therapeutic dosage compared to, the toxic dosage. The realities are different. So hopefully there's some recognition of that by the courts, but I doubt that. So my second best hope is that the court grasps the counseling relationship in addition to the treatment relationship in the additional language that was added to Michigan's medical marijuana back in April when they added the extra terms to the doctor-patient relationship definition. Because I think a counseling relationship in the realm of cannabis makes a lot more sense than a treatment relationship. And that's further emphasized by the new condition panel's acceptance of post-traumatic stress disorder. Because we've moved from the arena of physical injuries to mental health. And I think that is a distinction that the Supreme Court is going to have to wrap their collective heads around, so to speak, because cannabis is a different kind of medicine than most medicines, and its range of things you can use it for is far different than what we focused on for the most part in courts is chronic pain. There's a lot more to cannabis and medical marijuana than chronic pain. I'd guess, the way that Dr. Crocker has, and I mentioned Dr. Crocker twice, good for him tonight, but Dr. Crocker has explained for people who suffer from chronic pain, even for those individuals, one of the biggest benefits is what he described as the pain between the ears, and that is how you deal with chronic pain is as important as the actual source of the pain and whatever kind of injury or accident that you might have had. So I think these are critical expansions that the Supreme Court can't ignore and that are in complete conflict with the confused prescription analysis that was imposed by Judge Sad. So I'm quietly hopeful. I'm always quietly hopeful with the Michigan Supreme Court. Most of what they've authored, I would have authored a little differently if it was me, but like you said, for the most part, we've gotten good results out of the Michigan Supreme Court.
I have a question for both of you. Dan, this is Sharmi. Can you give me about 3 sentences to respond to the multitude of questions when folks ask me, how can a cop pretending to be a patient get away with this? Isn't that entrapment? So, 3 sentences on a straight level, please.
Yeah, no trouble. Sentence 1 is that the war against drugs traditionally has been fought with cops pretending and lying and being people that they're not. That'd be the only way to catch someone who's selling illegal substances is to pretend he's a buyer or user of pretend substances. So the court's familiar with that. Step 2 is that the court, in my case, ruled that the cop did nothing more than what any normal undercover cop would do when he's trying to buy drugs from an illegal drug seller. But my third sentence is, you can't go get a cocaine license or a methamphetamine license. You can't get a heroin license, but the state of Michigan issues patient cards for medical marijuana, and you have to swear or affirm certain things to get that piece of plastic, and you have to go see a real medical doctor. And that is the lie that I think my old trial judge didn't really grip onto, and I'm hoping my new trial court judge will.
I believe it's absolutely entrapment. I'm Dan's opinion, I think, can be, the opinion that he's talking about could be interpreted a number of different ways. I guess really that, it may never even be resolved because I think you might have a really good chance you're going to trial no matter what, and I'm assuming that's to preserve these issues for later on, win, lose, or draw, but you're not going to waive your right to trial. But, there may be a victim like that behavior may be enough if you're able to talk about it and, uninhibited, arguing about it as, clearly, making your client not guilty. I think that is as much of an impact as a good, as a good ruling, and it could dramatically affect the jury. The thing that I find that I thought that Judge McMillan made a big point about, and David Rudoy, jump in if you want to on this. There was no other evidence of the Carruthers situation of even any other sales. They never observed from within the store any other sales. The only transfers that took place there was to these people ask, this officer 3 times. So they couldn't even say that they were aware of other things. They said, well, some people go in and some people come out with the same bag that we had. But, when you look through the prongs of what must be established for an entrapment, it's the, escalating of a crime that would not normally happen. You actually have a situation here where, even though it, may have been different, the factual scenario was there was no other activity that was taking place other than this activity with this, enticement by this one particular individual. But I don't know if this argument was made. We kind of came up with this, David and I and Neil. It was right after Hartwick, and it almost forced us into this entrapment argument, which was we should, listen. This is an affirmative defense. It's a due process right. It's the most important, critical aspect of the entire, judicial system, and we're all supposed to ensure, the due process rights of the defendant. We should not be talking about, taking away the defense. It's just unheard of, and it would mean that, when we do this affirmative, this Section 8 defense, we're going to either get to a jury, as the law seemingly dictates, as the original writing of the initiative that was voted for, of a right to trial for registered and unregistered caregivers and patients for any matters involving marijuana. That's the principle by which should guide us. And the only reason why we wouldn't get that is because the officers intentionally entrap the defendants outside of their protections under the Act. So it's one or the other. Like the presumption is you're getting to trial because that's what the law dictates, and the standard of proof, Anderson and blah blah blah, you should be getting there. And because at the end of the day, this is the voters' initiative, and the voters, the jurors, are the ones that will decide it. I mean, do you agree with that analysis? I mean, isn't that kind of the way the Supreme Court has handled this in a big picture scheme?
Yeah, I think I do. I mean, that was some nuanced statements you made, but I think I'm generally agreeing with you on those.
Well, it's amazing that we're back to this. I mean, and I don't know that I don't know that the Supreme Court even understands some of the impact of the ruling, the impact on the day-to-day workability of the Act. I don't think they ever intended, for example, the Balsma decision to mean that if somebody finds a door that's unlocked, that means that they're committing a felony. I don't think that they ever intended that to be the case, but it's been one of the most abused avenues to take down caregivers. Like, it's been a crazy political, more politics in the law than I think I've ever experienced in my practice. I don't know.
Well, that's a practical major problem. I mean, we've said that we've liked a lot of the Michigan Supreme Court's opinions on medical marijuana issues, but the problem is that the way that they've done their analysis, it leaves a lot of doors open for the prosecution to do rapid workarounds, or even to make things worse, even though the opinion reads pretty well. And that's always my fear when you have smart guys thinking about stuff who don't actually spend a lot of time in courtrooms. They can do things that academically seem perfect, but when they apply in the courtroom, they can create a lot of problems.
I would also say that I don't think the Michigan Supreme Court has been that good on medical marijuana. I think that they've looked good in comparison to the horrible Michigan Court of Appeals, which has just done everything they can to shred the Michigan Medical Marijuana Act.
Yeah. I think that's a real good analysis. It feels good when you stop hitting your head against the wall.
It was kind of an okay case, but I think it's crazy that you lose your Section 4 protection if a door's unlocked. Doors have to be unlocked sometimes to walk through them, but if the door's unlocked when the cops come,
but I don't think that
protection. When your house itself is a locked facility.
Well, listen, that's my point. They don't really that case is not about locked and closed facility. That case is about possessing more plants than you're allowed to. The underlying ruling was, how could it be said after rereading the testimony of Balsma at his, pre-Section 8 hearing that he possessed more than the 24 plants he was allowed to possess? That's why he lost. In fact, the facts of that case were that the building inspector broke into the warehouse and found this interior grow room with 3 open doors. They don't say that was the reason why Balsma loses his Section 4. That's the scenario we've all become accustomed to hearing and understanding, that somebody might be able to, jump through a electric fence and do a cartwheel and super glide into and underneath the, webbing and just they can get in there and get their arm in and grab it. That's not locked in and closed. Like, this is insane. That's not the issue. The issue is, can it be said that the person who is claiming the possessionary amount, because when you get down to 4D, do they mention enclosed lock facility? No. They focus on the card and the quantity. These are the principles by which the immunity section is derived from, and it's not. It's like an afterthought in closed facility. Dan Groh, thoughts on that?
I totally agree, and in certain situations, it really has disastrous effects. If you take a husband and wife situation, a typical hot day where they've got some doors open and people are moving around, and there's no one in the world that can have a legitimate claim that they can walk in and take this marijuana from anybody. I mean, they're home. They're guarding their own house. But the doors at that instant that the shops show up might happen to be open or ajar or has a key in it but not locked. And, I mean, these are the kinds of cases that we see in the courtroom a lot, and it's really, really unjust.
Because it's not about whether or not the door is locked, or you might abuse your baby, or whether or not you've got too much usable marijuana on you. The reason you guys are in the courtroom like this, and the reason we're still all under attack, is so that they can maintain the status quo and continue fighting the war. I'm not an attorney, but every time I've been in the courtroom, it's abundantly clear that that's all that's happening.
I totally agree with that statement as well.
Yeah, I mean, it's not being argued that much. I know some of these other court of appeals, but David, your case destroys, what we're talking about right now. I know it's unpublished. Did you get a chance to read Dan Groh? Let's talk about David Rodoy's case. I don't know if you. It's David. Give us a little synopsis of Section 4 case, 4I.
Okay, so it's a Section 4I. My client is the wife of a caregiver who basically his door wasn't locked, and he also had guns in the house, and he was afraid because of the felony firearm, which is a 2-year mandatory minimum. So he decided to plead guilty to these felonies and get no jail time. And that's the only he had legitimate defenses, but he has kids that he has to take care of. So he was scared of 2-year mandatory minimum, took the deal. And their evidence against my client is a sticky note that she wrote on, harvested on, used on when her husband asked her to write on a note because his hands were sticky up at the kitchen table. She never had access to the grow room. And we asserted she was merely present, and they found that Section 4I doesn't apply because he pled guilty and because the door to the room was open at the time of the raid, that he doesn't get any Section 4 protection, and Section 4 states that you're immune from, prosecution for the mere presence around the medical use of marijuana in accordance with this act. And they interpreted that in a completely illogical manner. This is a public act.
Him not being in compliance with the act ruined her immunity because she's trying to remain, merely present. But
the insane part about it is that for her to remain merely present, she has no way of ensuring that her husband is in compliance. So if she were to have participated in some way to make sure that he's in compliance with the act, she would thus no longer be merely present. So it was an entrapment by estoppel situation. The Court of Appeals didn't even acknowledge that argument in their opinion at all. I'm pretty sure they got most of their ideas from the prosecutor's earlier briefs. And where does
that case stand now, David?
Well, they just issued the opinion on Wednesday, and very soon we will be filing a brief to appeal it to the Supreme Court, I believe. I haven't gotten the final okay from my client. The problem with it is the Court of Appeals, at the end of their opinion, suggested that she's got some very good trial defenses.
Because I was going to say that. You know why? Because you still have the merely present defense at trial. There's a defense in the jury instruction. It was Section 7, I think, of defenses, or 8, whatever it is. But and it even includes knowing that criminal activity is taking place at the location and not being part of it. Still allows the jury, instructs the jury to find you not guilty. Dan, would you agree with that?
Yeah, depending on, I haven't read the opinion, but it sounds like that might be an important thing for David to look into to the extent that he's getting ready for trial. The whole thing's upside down. In the beginning, when they first adopted the act, it was my position that the the adoption of the act was basically the voters of Michigan telling law enforcement to back off, just leave us alone generally. Not let's make the most complex and absurd system possible, so basically ensure that anyone who decides to become a patient or a caregiver is faced with a bewildering set of choices that are all likely to result in a felony prosecution. That's not what Michigan voters asked for, and I really hope, the direction in the courts changes so we don't have this as an ongoing problem.
I mean, I think, these last two, at least
that was beautiful, Dan. That was beautiful. Thank you.
When you look, yes, it was very beautiful. The Tuttle case, in our Carruthers case, and even your Miller, is that his name?
Yes.
They're all kind of, even though they're defined as different issues, they all really relate to the same thing. The whole thing with Tuttle is that the sale to the undercover or fake patient results in the entire immunity being vitiated, and any other activity that's taking place inside is being outside of, which I think is, which is like this very, very, non-patient friendly interpretation, and raising a lot of issues of, with this entrapment. These things are completely overlapping with one another. To what extent are we going to allow this police activity? Why is there creating the need for this when, as you said, the initiative itself is intended to reduce the number of arrests? The preamble speaks of looking at his medicine, and there's just this is intent being to reduce the number of arrests as opposed to increase them. I don't know why are we still at this point? Is it is there an individual to blame, or is it?
It's a very highly organized strategy against us from the very, very beginning. And a lot of other states don't face what we have. You guys don't understand what super badasses you all are, because we have been under attack since before the act was passed by the courts, by the county prosecutors who are all out of control. It's certainly not the voters. It's absolutely not. The doctors are being persecuted. You know all this, but it's really, seriously, we're under attack in ways that many other states haven't been. As the states increase in their numbers of medical marijuana, states, however, there are some that are incredibly restrictive, like Rick Thompson, like Rhode Island. I think Washington, D.C. as well, maybe. Right, they're very strict. But they don't face that. Yes.
I can offer a suggestion of why Michigan is receiving the treatment that it is as opposed to some other states. Many of the other states have far more regulated systems. Michigan gives human beings, normal human beings like the people on this conference call and on this radio station, the ability to do something powerful, the ability to heal themselves without much guidance from a doctor, without going to the pharmacy. And I think it's a major threat to those who are real pleased with the industrial pharmacy, hospital / military industrial complex. The Michigan system with home-based growing is a real threat to those folks. And I think they are going to throw whatever they can throw at us, even if they can trick us and get us to adopt some kind of a dispensary system that's purely government-run. Those things make me afraid, and that's why I'm such a strong advocate for medical marijuana, because it puts the power back in the hands of regular people to control their own lives, and I think that's critical.
Because we need to have informed healthcare options that stand alone outside of the current Western medical system, which is enforced through the courts and at the end of a gun. We need to have our rights that are held and honored instead of being regulated away. What we're seeing with medical marijuana over the last 5 years has also been enacted on other sorts of health care that isn't approved upon, per se, by the American Medical Association. I had a midwife friend call me in the last several months and say, Charmy, I helped a mom transfer to the hospital, which sometimes happens with home birth, you're in labor for 4 days. You're like, hey, let's go to the hospital. I'm exhausted. So she gets this mom to the hospital, does her thing, hands over the files, and gets home, and there's a detective waiting for her. Because
oh, my God.
Gray area, they're not quite sure about home birth, whether or not it's legal. She said, Charmy, I'm not going to midwife anymore. I'm not like you. I can't fight these people. I have a family. Okay, so my hackles are raised. If you cannot mess with other women helping other women give birth. You can't do that. We're the healers. This is what I say every time I come here to this show, but we're under attack. And the next thing we have to do is disentangle our rights from the existing Western medical system, I think.
We have about 5 minutes left, but we're going to go over a little bit. Go ahead. No, we're going to go over a little bit. Go ahead, Dan, sorry.
When the prohibition of alcohol went away, the women had a big play in that. So, but anyways, go ahead.
We're going to go over a little bit if we don't finish our conversation. But so those that are listening live can continue after the hour mark, and it'll all be archived. Those that are listening on the computer. But we're talking about. So it's kind of interesting. I think Dan. There's the information that you're relaying. It's because you're a lawyer, and you get the bad calls. I mean, there's very few people that call your office and say, "Hey, Mr. Groh, I just want to tell you I had a fantastic Section 4 encounter with law enforcement, and I'm not going to need you, but I showed him my card, and I drove away. He didn't want to see how much I had. He didn't want to see my grow room. He didn't want to come. None of that. You don't hear that. We only hear like, oh my God, you don't believe what they did to me. I just got out of jail. I showed them my card. They didn't care. After they arrested me, they broke into my house. They took this. They took my forfeiture. Blah blah. So it's always like a nightmare as far as it goes. And we see the worst of it. And while this is going on, and really what is almost in dire contrast to what would appear to be a national trend, real national trend for the acceptance of medical marijuana. And even marijuana reform. I mean, you can't deny, across the you can't be not listening to not feel the waves of that. And even the legislative process of potentially moving forward a provisioning center bill, in a way that seems to empower the concept of a business. But I mean, I don't know that. I mean, do you think the engagement of the individuals in these battles that you're having are thinking in an acceptance way of, marijuana businesses, and how willing are they going to be to accept them?
Well, you mentioned the word business. I mean, any time that someone offers a good or a service that's useful, there's usually someone on the other side of the transaction who's willing to either beg, borrow, steal, pay, barter, whatever. There's always going to be an arm's length transaction when you have something that's worthwhile. There's not too many people that raise cows to eat hamburgers, and there's not too many people who raise chickens just to get eggs. For the most part, you specialize in one thing and delegate to other people that have their respective specialties to handle things. Like when I print out a brief, I don't have to make paper. I go buy paper from someone who's real good at it. So I think part of the tension that we have in our present system is that we have a home-based system for supplying something that's really valuable to a lot of different people for a lot of different reasons, but we don't have an economic model that fits the realities of the situation. So then we combine that with this general notion that we face in the courts that if you're making money off of marijuana, you're breaking the law. But that's that fights this basic notion that if you're doing something that's worth a damn, there's someone willing to pay you to do it. So that creates, I think, a whole level of problems that can only be solved by recognizing that marijuana or cannabis should not be a Schedule I substance, shouldn't be scheduled at all. I think until we have that realization that marijuana is a safe thing that's useful, not an unsafe thing that has no use, everything else that happens isn't going to make much sense. So, and if we have that realization that it's a safe thing that's useful and not an unsafe thing with no use, there'd be no reason to treat it differently, like your other guest said, than tomatoes. There'll be big growers of tomatoes. There'll be home growers of tomatoes that make specialty tomatoes, heirloom tomatoes, whatever. But it just shouldn't be the government's problem. It's a health problem. It's a personal privacy problem. And if there's people that abuse things, I just read an article. It's the first death attributed to marijuana in Colorado. Some 19-year-old kid probably took way, way too much marijuana and apparently jumped out a window and he died. Is it because of marijuana, or was it because you had a kid that was partying and was doing something exquisitely stupid and he would have drank too much booze and jumped out a window, or smoked meth and jumped out of a window? This kid was going to get screwed up and jump out of a window.
Sometimes
was it
people
marijuana's fault?
Windows without drugs as well.
Oh, I mean, yeah, I've been close. I've been close, but so I mean,
I think I've been there, Dan.
Yeah, I know. It was your fault. Just joking. Yeah, so I mean that's my predisposition on the thing.
Well, Ed Rosenthal was on earlier. He's speaking at Hash Bash, and he kind of, he's got a whole section of his book he was reciting from regarding the tomato analogy and the way in which he envisions the market. I'd asked him about whether, and you hit the nail on the head, the beauty of the Michigan system, the caregiving system, is that individuals can grow 72 plants. This is an amazing thing. It's like it's unique amongst all the other states, a huge potential commodity for the marketplace, and it's a real challenge to, government-run and controlled situation because it is so deregulated. I asked Ed because I think if you went to a conference, the progress of things, there'd be a pamphlet of how to do it like Colorado, but he believed that it's over. Like, we're moving in a direction, this is going to be over, nothing to fear, it's happening, it's rolling out, and tomatoes aplenty will be grown in various stages, just like the tomato industry now. I feel, my comment was, isn't the federal government holding the wild card in all this? Don't they have a lot of money to be earned? And we kind of talked about, what are your thoughts on that as a 2 to 5 year to 7 year overview?
Well, I'm not a big fan of centralized government in general. I don't want to give any of my money to the federal government, whether I earn it, practicing law, or if someone was to make it helping people with cannabis. I think the federal government is terrible shepherd or keeper of our money, and I think the central government does terrible things with it, including waging wars overseas and killing innocent people and all kinds of other terrible things. That's not my preference, so I don't want to do anything to make this federal government richer. I would suggest I'd be perfectly happy just having it a home-based business for everybody forever. I don't have a problem with that.
Is that workable, though? I agree with you. Because, to me, the challenge as we move forward, and once the community starts talking about business, then comes the regulators, then comes the control, and then comes the concerns, and then comes the, whatever reason they can come up with to take control of it and manage it. But that's obviously what it is. And the existing act alone, standing as it, without conceptualizing dispensaries, was about the most free and unregulated that could exist. The argument of whether it works or not is another story. But is it the type of thing that can actually exist as you describe it, or is there just too much money here that the federal government's not going to be able to let go by?
Look at the Canadian model. Look at what they just did in Canada, which was an attempt to take away home grows to do exactly what you're talking about, Michael, for the government to gain control of the production and regulation, and therefore all aspects of profit making from the venture.
If they make it a Schedule 2, imagine what would happen if people started making Vicodin in their basements. There's going to be more money by the drug manufacturer companies to police and punish that than they have for marijuana eradication. You know what I mean? So, and not everyone's going to be able to grow and use Schedule 2, or be licensed for it. It really limits them. So, that's a play for, a grasp for money. That would be the production of this of marijuana as a Schedule 2? I'm sorry. Go ahead, Dan.
Well, way back when we were first talking to folks, when Michigan first adopted its act, I was in a partnership with John Targowski, a guy that everyone on this show knows. And we would have meetings with folks, and this was way back in the early stages, and people had no idea what to do. And John was always of the opinion that, you should start a bank account and keep track of your spending, and, because someday this is going to be taxed and stuff. And then I would say, well, maybe that's how this is going to go out, but, it's still illegal, and I think you should probably keep a low profile as possible. I mean, just, there's two ways that you can do the analysis. And I think in the future, it might come to pass, well, hopefully we maintain a home-based growing system so people who don't want to be involved with the corporate end of medical marijuana can, or even just marijuana for no reason. I mean, recreational marijuana is safer than alcohol. So I'm a big proponent for recreational marijuana as well. But if you want to stay out of the economic system and grow at home for you and your 5 closest friends, I don't see any reason in the world why that should be anybody's business. But if you decide to open a store and maybe sell marijuana-infused products or have hash oils or extractions or anything like that on a retail basis, I think you have a responsibility to your customers, one, to be candid and frank with what's in your products, exactly which active ingredients are in there and what amounts, whether it's free from pesticides or whatever else. And I think self-reporting will make the honest, good manufacturers market leaders, and people will give their dollars to the honest stores. And those honest stores might make a buck, and if it's income in a retail context, they should not have any special rules. They should be the same rules if you're selling tennis shoes or tomatoes or anything else. You can't lie. You got to be honest about your product, and when you sell it, your government gets a cut. I mean, if you're going to have a commercial experience, it's going to be commercial. If you're going to have a home experience, it should be nobody's business. And I don't think there's any reason why both those things couldn't exist at the same time. And to the extent it's not scheduled, I mean, there's no reason why the average family might not have a cannabis plant grown in their backyard just in case. And as a practical matter, if that was what happened, the commercial aspects of cannabis will be more difficult because cannabis grows relatively easily. It's they call it weed for a reason. So the unit value or price of cannabis will drop to a level where maybe there won't be a big incentive to have major retail cannabis outlets, because if you want some, you just grow some. But then there'll be everything in between.
Excellent. We're going to revisit this every year for the next 10 years. And
same thing Ed Rosenthal said.
It was, wasn't it? Yeah, I mean, that's...
I miss Ed, but maybe Ed and I should talk.
That's the real... I mean, that's I think, the ideal that we get to that level. So it's not... But, whether it happens or not, whether... there's a lot of factors out there, I think. I mean, we would agree about that. There's an ideal of how it should be.
Legal to make it there. It has to be not a controlled substance anymore.
Right, but I don't know. I mean, I don't know that everyone's thinking about the solution like this conversation is taking place. I think, maybe it is. I don't know. Maybe
the crucibles of democracy. Let all the different states have different programs, and then we adopt the successful portions of those other programs.
I'm down with it.
That's why you're my friend, Rick, because you say things like the crucibles of democracy.
Well, it's not my original quote, but yeah.
All right. So, do we solve anything here? Any final thoughts as we begin to shut it down? Dan, first of all, Dan, thanks so much. Really nice talking to you. Very insightful.
It's always a pleasure to be here and share ideas and spread some kind of good news, I hope, or at least some good ideas.
Absolutely. Thanks for joining us. Have a great night, and we look forward to talking to you soon. Thanks again.
Take care, David, Charmy, everybody.
All right.
Bye, Dan.
Peace, Dan.
All right, Dan Groh, that was fascinating, the way the law, 6 months to 6 months, how it can change in terms of the the value of it. I mean, the tools given by the Supreme Court for the Section 8 affirmative defense after Anderson were powerful,
robust.
And these last two cases have just
eroded.
And this Court of Appeals is very, very, very
What's
bad
the record now?
people. They're bad people.
What's the record on the Court of Appeals?
Yeah.
I'd like to know, Mr. Rudolph. Who was keeping tally on that?
It was 19-0 at one point.
And then we thought we had one or two positives, but
was good.
Yes, that's true.
Mm-hmm.
Green.
I have to believe there's been a couple more.
But Green was based upon faulty.
Immediately overruled.
Yeah, I mean, it's just based on I think it was
good for how long? A couple days. Yeah.
I mean, it didn't make any sense.
I'm still abiding by it.
But it was a positive Court of Appeals decision. If we were to tally, it would have to go in the yes column.
Don't tally the tally.
Wow. Just said dally.
All right, so
This is where you put the music on in the background and wrap it around here.
is this working right
Yes,
now?
I can hear you.
All right.
Jamie, please.
Obviously, Hash Bash and Monroe Street Fair coming up this weekend, and we have the Third Coast sponsored official T-shirts, and Daryl will be out there by Dominic's early on Saturday with a bunch of them that he'll be giving away, and so that'd be a good time to go get one, and then you can wear it and walk around and advertise for us. Also, the announcement came out about several cities doing local ballot initiatives, and next week we'll get into that a little bit further with Chuck and Tim and others.
I failed to mention that.
Excellent. Chad, any final thoughts?
No thanks. I'm good.
Very good. We'll believe you. Charmy.
Lift your heart.
Excellent.
And we'll get to the patient testimonial. I guess we didn't recognize the number as being called in tonight, and so we'll see if we can arrange that for next week.
For the Cannabis Cures Cancer series.
We're a little askew. We had the
technical difficulties.
We had a little technical difficulties, and also, we did the show early. We actually promoted it a day early, and it was a little bit off kilter a little bit.
Because of the advance notice given to our...
Exactly. David, final thoughts and comments.
I'm just going to agree with the Court of Appeals being evil with your previous statement.
They're bad.
Let's hope that the Supreme Court starts bailing us out again on various cases.
I like to say they start rectifying the evil, rectifying the injustice. All right, so...
I'll take my final thoughts.
Did I pass over you, Rick? I'm sorry, please. Please.
With all the excitement about this weekend in Hash Bash and people coming to town, and we're hearing some big names, and that's wonderful. But it concerns me when I hear things, and not to discredit Mr. Rosenthal, but when everyone says things like, it's a lock, it's a done deal, we don't have to worry about it anymore when it comes to marijuana law reform,
come home.
there's a lot of issues that are unresolved. We're seeing in Italy, when they rolled back the marijuana laws, they released 10,000 prisoners from their prisons, realizing that they'd been unjustly imprisoned. We can certainly do that here. We have to be cautious about government evolution of the marijuana laws, too, because it can go in the direction of the Canadian government model. So it's far from a lock. It's far from over. Although societally, we have achieved what we wanted, acceptance, which is growing at a rate that no one can stop any longer. Legislatively and governmentally, we still have a long way to go, and the lobbying efforts shouldn't discontinue, and people should still join organizations that support your causes, and make sure that you show up at the polls and when to vote, because it is not over. I'm concerned about that mindset, and that's it.
Keep on fighting, in other words.
Keep on fighting.
Keep on trucking. All right, very good. Thank you, everyone, for listening. All our guests for calling in. Jamie, good job putting the show together. Charmy, thanks for special appearance. It's always fantastic. We didn't really get enough time. It's because Jamie booked the show so tight.
He's a bad man.
He's a good man. He's a good man.
It's a good thing he's quiet.
Would have gone off without a hitch, without the technical difficulties taking place.
Take full responsibility. And David Rudoy, thanks for sharing about this terrible opinion. What's wrong? What's going on? Jesus.
Rudoy looks good, too. He's got that pop-top collar going out there. So he's all stylish. Yeah.
This weekend starts now.
I wish.
Anyway, thanks for joining us. We will see you. Yes, we see you as we do every week next week. And be safe, and we will talk to you then.
Geometry, so we're saving up for that right now.
What is that shit?
I don't know.
I've got a fucking shitstorm going out my fucking ass here.
Shouldn't be hard.
So, in the
This preparation dictated from God to Moses is for healing. It's incredibly powerful. Our leaders need to know this is from God Himself.